This is Bloomberg Law with June Grasso from Bloomberg Radio.
A Texas judge struck down the FTC's ban on non-compete agreements before the ban even went into effect, blocking the agency's effort to make labor markets more competitive. Non-compete agreements have become increasingly common, with an estimated 20% of workers, that's about 30 million Americans, subject to them. Last January, President Joe Biden touted the FTC's overhaul of the rules, saying non-compete clauses are overused and often make it unnecessarily difficult for average working Americans to get better jobs.
It's another thing to say you're working for Subway and you can't walk across the street and go to Jimmy John's and get a 20-cent raise. What tells that all about other than keeping wages down?
But Texas Judge Ada Brown, a Trump appointee, said the FTC lacked the authority to enact the non-compete ban and tossed it out. Joining me is William Kovacic, a professor at GW Law School and the former chair of the FTC. The judge said in her 27-page ruling that the FTC's proposed rule was arbitrary and capricious and would cause irreparable harm. Can you tell us more about her decision?
Judge Brown had two grounds for suspending the implementation of the rule, vacating it. The first is the one you mentioned, which is that the FTC lacked an adequate basis to support the scope and the complete reach of the rule. That is, the rule applies to a very broad range of employment contracts. There are a couple of carve-outs, but the judge concluded that you lacked a sufficient evidentiary basis to implement that rule, and therefore the rule itself is arbitrary and capricious. The second basis for rejecting the rule is her conclusion that the FTC lacks the legal authority to adopt rules involving competition policy. That is, substantive competition rules are beyond the FTC's remit. This involved a fairly elaborate and technical analysis of the FTC's authority going back to 1914 when Congress established the FTC Act and coming forward. But her review of the original framework and its subsequent evolution is that the FTC simply lacks legal authority to adopt and apply such a rule, so that on that basis as well, the rule was suspended.
Do you agree with her reasoning?
On the second point, I do. It's always difficult to decide when you have a good fit between the substantive rule and the underlying basis. I think what's a matter of concern is that, first, it's an extraordinarily broad rule, and unashamedly, it applies to the laws of 48 states that currently allow various forms of non-compete. It involves, as the FTC emphasized, hundreds of billions of dollars of wages. There are tremendous economic stakes here. This is very clearly a major extension of the FTC's oversight role in labor-related agreements. You would think that for a measure of that part, you would have to have a fairly extensive and careful review of the existing literature, pro and con. I would say in many ways the FTC took shortcuts on that and tended to brush aside views that it found to be incompatible with its policy preferences. And I think that did create a real vulnerability with respect to the arbitrary and capricious issue. The argument about the FTC's authority is ambiguous. There are certainly plausible arguments that the FTC has the authority. My intuition is that given the current direction of Supreme Court jurisprudence involving the grant of authority to administrative agencies and the effort of administrative agencies, regulators, to interpret their authority in a way to meet new conditions and to stretch, in some sense, the application of their authority, the current Supreme Court is skeptical about that. The current Supreme Court says, if you want to do bold things and to apply the law in a broad way, we want you to anchor that in a clear statement of congressional purpose, that Congress, to allow you to do bold things, has to say so clearly. The direction of travel of this doctrine runs against the philosophy, the interpretation approach that the FTC is relying on here. Goodness knows how the Supreme Court would ultimately evaluate the rule. I haven't talked to them today, so I don't know exactly what they'll do. But my inference from the current direction of their jurisprudence and the attitude that's embedded in that jurisprudence is that this rule would have a very difficult time surviving review as it goes up to the court. and that Judge Brown's ruling here is quite likely to be sustained.
If the rule had been narrower, let's say it just applied to low and middle income workers, do you think that it would have passed muster?
I think, June, if it had been limited in that way, if it had been limited to, say, low-income workers who are engaged in applying skills that arguably don't involve the special training and conveying of know-how that might take place in other settings, if it had been tailored to that specific concern, I think the rule would have had a better chance of sidestepping the arbitrary and capricious ruling that Judge Brown found here. It would still perhaps run into the concern about whether the FTC has the authority in the first place. That is, Judge Brown's conclusion that the FTC lacks authority would mean that even a narrower rule would not be permissible unless Congress were to come back and clearly give the FTC authority to do it. But I think a narrower rule would have had a stronger chance of surviving review in two respects. One is that it would be less likely to be found arbitrary and capricious. And the other is that there's another issue lurking in the background where the Supreme Court recently has said if you purport to do path-breaking, economically significant things by rulemaking, you have to point to specific grant of legislative authority to do that. In other words, as the court has said, where your initiative raises major questions about the operation of the economy, for example, you have to be able to show more precisely that Congress intended for you to address those major questions and to adopt rules to treat them. That is the basis on which yet another court in Florida, federal court in Florida, issued a preliminary injunction concerning the application of the rule. So when we take all of these, I would say, skeptical streams of jurisprudence, the FTC is traveling into a very difficult storm, and that a narrower rule would have helped avoid the arbitrary and capricious ruling. A narrower rule would be less likely to raise concerns under the major question doctrine, but even a narrower rule would run into the concern that Judge Brown showed that the commission just doesn't have authority to issue any rules involving competition.
How about another agency doing this? The National Labor Relations Board's top lawyer is moving ahead with an enforcement strategy to make restrictive covenants illegal. General Counsel Jennifer Abruzzo says such pacts deny workers the ability to quit or change jobs, which in turn interferes with exercising their organizing rights in their current positions for fear of being fired and not being able to obtain new employment. Do you think a rule by the NLRB would survive?
I'm less familiar, June, with the specific grant of authority that the NLRB would be relying upon. Certainly in the application of its adjudication function, that is in the prosecution of individual cases, it would be less likely to run into the question whether it has rulemaking authority, which is the issue in the FTC proceedings. The question for the NLRB would be, in its law enforcement capacity, has it appropriately interpreted the mandate that Congress gave it, and would reviewing courts conclude that its interpretation of its law enforcement mission encompasses the concerns that the NLRB Solicitor General has raised about non-compete. So the NLRB might be in a position to challenge these. I don't know if they mean to do it by rulemaking. And I would add that the FTC does have authority to challenge individual non-compete agreements using its law enforcement mandate. It has a law enforcement mandate to prohibit unfair or deceptive acts or practices or unfair methods of competition. That involves case-by-case adjudication to challenge specific arrangements. That authority is not endangered in the challenges that are present in the federal courts now. The FTC can continue to do that. That has the disadvantage that you go step by step and you don't have the capacity necessarily to adopt a broad-based prohibition that applies across the country and condemns all of the arrangements. It's a more laborious way to get to the final destination that you wish to achieve. That path is still open to the FTC. That kind of litigation, I assume, is open to the NLRB. That case-by-case litigation approach is available. The district judge decision in the FTC case deals with the effort in a single rule to achieve what otherwise be attained through a collection of cases over time.
How big a blow do you think this is to the FTC?
I think it's a significant blow. When I look at the whole fan of the FTC's program since the Biden administration began in 2021. I would characterize this as the most significant initiative that they pursued. Most significant measured by its purported economic impact, its anticipated economic impact, which is self-described as being very broad. Most significant in terms of its effort to move the doctrinal framework of intervention outward, to gain acceptance for the idea that the FTC has power to issue these competition rules and include powerful prohibitions in them. And third, symbolically, it is held out as an example of the Biden FTC's willing to take more risks, to be far more ambitious than its predecessors are, and as such to bring a new attitude toward the application of federal power to control commerce. In all of these respects, I would say in the entire fleet of FTC initiatives, this is the flagship. And if you are running a Navy, you don't want your flagship to be sunk.
In a statement, FTC spokesperson Victoria Graham said the agency is seriously considering a potential appeal. Do you think they should appeal this? Because it's going to the Fifth Circuit, which is ultra-conservative, has a reputation for overturning Biden administration rules, and then likely to the Supreme Court where, as you mentioned, I don't think they'll find a receptive court.
I think they should. If I was guiding the strategy, I would do it. One reason is that the FTC has had some surprising success over the past year in front of that very court. It was in the context of a merger challenge to an acquisition by Illumina of the Grail Company. It was an appeal from an FTC administrative decision, a law enforcement measure. The parties opposing the FTC raised 4 distinct constitutional and administrative law challenges to the FTC's authority. In addition to challenging the FTC's decision on the merits, I think that they thought they'd gone to exactly the forum that would be favorable to them. They didn't quite get the panel that they hoped for, but the panel they did get basically brushed aside all of the administrative law and constitutional law challenges. It upheld the FTC's decision, and in a sense, it showed that even in a very difficult litigation environment, you can prevail. So it's not a hopeless pursuit. And another reason I'd bring the case is that I think it would demonstrate the conviction of the agency to take on hard, difficult matters, notwithstanding the possibility of failure in the court. You're ultimately going to have to face a judiciary, perhaps ultimately the Supreme Court, that has raised issues with this form of approach. My suggestion was have it out now, get the appellate decision, take it up to the Supreme Court and say, we need a basic decision about the framework of FTC authority generally and about its application of its asserted authority in this instance. Let's not wait for another case or another time. Let's bring it to a head now. And if the result is adverse, we go back to Congress and say, if you want us to be active in this area, give us a clearer mandate to do so.
There are non-competes at the state level. 4 states have banned nearly all non-competes, and at least 11 more have thresholds protecting lower income, middle income, hourly workers, etc. Do you think we'll see more states trying to pass laws about non-competes?
I think we'll see an amendment of the legal framework, and this is a respect in which the FTC's initiative, despite the risks that I've been describing, in a sense, has achieved real success. It has drawn broad attention within the United States to the issue of non-compete. It's catalyzed reconsideration of the existing legal framework, which, with the exception of a handful of states such as California, does not prohibit these agreements or render them unenforceable. Most states allow them to be evaluated by a reasonableness standard. The FTC's initiative has inspired a new debate about whether or not these kinds of restrictions are appropriate. So I think we're going to see a rethink in many states that allow these arrangements under a reasonableness standard, to rethink that approach, perhaps to create presumptions against them, to apply prohibitions that exist now on certain non-competes more broadly. So we could see in the states a restoration of bolder enforcement and scrutiny regarding non-competes, notwithstanding the result that comes from the federal litigation itself. And I think you point to a result that the FTC probably had in mind in taking a very bold approach here, which was to change the policy debate, to bring about indirect effects, including in the state government. And I suspect if we were to give truth serum to the leadership team at the FTC, the FTC might say that is an important measure of success by itself, and that made the entire effort worthwhile, even if our own specific initiative is not successful.
I've been reading, and, some articles say management is back in control now. This is a huge win for management. Do you agree with that?
I'm afraid that's a bit like saying that the match is over when there's still many minutes left on the clock. So there's a temporary reprieve, but there are still, as Jimmy Cliff would say, many rivers to cross before you get confidence that the status quo, which allows many of these arrangements, stays in place. So it's way too early to speak so confidently about things, especially because of the point that we just mentioned. There are some limitations on these agreements at the state level, and I think the FTC initiative, even if it fails in the courts, has set in motion a policy rethink that's going to spill over through a number of jurisdictions. So I wouldn't be comfortable in simply sitting back and saying the storm has passed, the status quo prevails. I think that is not a completely thoughtful understanding of what's taking place now.
As you say, a lot more to come. Thanks so much, Bill. I really appreciate your insights. That's Professor William Kovacic of GW Law School. A divided Supreme Court refused to bolster the Biden administration's ability to extend protections against discrimination in schools to transgender students nationwide. In an unsigned order, the justices left in force two lower court orders that are temporarily blocking a new education department rule in 10 states. Joining me is Chase Strangio, Deputy Director for Transgender Justice at the American Civil Liberties Union. Tell us first about the education department rule that's at issue here.
The federal law that prohibits sex discrimination in educational programs that receive federal funding. And Title IX has regulations that the Department of Education has promulgated over the years, and the Biden administration over the course of the last several years has been working on an extensive rule implementing provisions of Title IX that were subject to notice and comment, and we're set to go into effect on August 1st. And we're talking about 1,500 pages that cover a lot of different areas of issues related to sex discrimination. The subject that has received the most attention, that's been the centerpiece of litigation over these regulations, concerns transgender students and protections for transgender students in educational settings. First, at the sort of definitional threshold level, whether or not Title IX itself includes discrimination against people who are LGBTQ. And then specifically, there are sort of two central provisions that have been the subject of litigation. One concerns the inclusion of transgender students in sex-segregated spaces, most specifically restrooms. And then the other concerns the interpretation of basically what is a hostile environment harassment under Title IX. And in particular, the context that has been the subject of most of this conversation has to do with pronouns for transgender students. So those are two, very discrete areas that have been the subject of litigation in a rule that covers, extensive areas of federal educational programming, including protections for pregnant and breastfeeding students and other areas of interpretation under Title IX. So that is the overall context that we're dealing with when we're talking about the recent set of cases that ultimately made their way up to the Supreme Court shadow docket.
Federal trial judges in Kentucky and Louisiana issued orders temporarily blocking the rule in 10 states. So did they block the entire rule?
Yes. So there has been a number of different cases proceeding through the federal courts and the appeals courts and the district courts coming out of three cases, one in Kentucky and two consolidated in Louisiana, enjoined the entire rule, not just the provisions related to the sex-separated spaces and the hostile environment harassment language that were the actual subject of the litigation that was brought by the various states and, in some instances, localities.
Was the reasoning of the two courts the same or similar? Why did they issue this temporary injunction?
I think there's sort of two sets of questions about, why did they issue the injunction? The first is sort of on the merits. The argument as to the provisions that the litigation focused on were that the interpretation of the rule exceeded the administration statutory authority under Title IX. And that was the main substantive merits argument. In essence, the protections that the statute affords from discrimination based on sex did not include discrimination against transgender people, and in particular, not in these discrete ways. So those were the merits questions, and the courts held that they were likely to succeed, that the administration exceeded its authority in promulgating these rules. Now, as to why the injunction swept so broadly, the argument there, I know it wasn't even really advanced by the states themselves in litigating these claims, was that the rest of the rule could not be severed from the injury that they complained of with respect to the provisions related to trans students. That is the argument, and that is the basis for the sweeping injunctions that reach across, all of the areas in which this Title IX regulation covered, and like I said, including related to, general protections from discrimination for pregnant and breastfeeding students. And so the decision from the court was that, they couldn't sever the various provisions.
And the Solicitor General had only asked the court to allow the other provisions to be enforced while the legal fight goes on?
Yes, that's correct. So there had been a motion for partial stay that had been filed in the appeals courts in the 6th and 5th circuits. And the motion for the partial stay was only seeking to stay the injunction with respect to the provisions that did not concern the single-sex facilities and the hostile environment harassment. So in essence, saying they're complaining of injuries with respect to these two discrete things. We're not seeking to block the injunction with respect to those, but it sweeps too broadly, and we are seeking relief from this incredibly broad injunction that prevents us from implementing this critical rule protecting students and staff from sex discrimination in education. So that was the stay they sought from the lower federal appeals courts. Those were denied at the appeals level. And then ultimately they went to the Supreme Court seeking the same stay with respect to the rest of the rule and not challenging the stay with respect to the two provisions that I was mentioning, the hostile environment and the single-sex facilities. Now, there is a somewhat complicated piece to all this, which is that it is in part complicated because of how the Supreme Court ultimately dealt with it, but there's a definitional provision at the center of all this as well. And the SG's office also sought a stay of the injunction with respect to the definitional provision. And that definitional provision, is in essence the piece of the rule that defines what is sex discrimination for purposes of Title IX and explains that sex includes gender identity, sex stereotyping, pregnancy status, and this broad understanding of what it means to discriminate because of sex under Title IX. So this definitional provision was also at the center of the litigation, even though the states that brought the initial lawsuit never complained that they were injured by the definitional provision. And if you think about what that, means in essence, the idea here would be, certainly after Bostock, which held that under Title VII, sex discrimination includes a prohibition on discrimination against LGBT people. In educational settings, a school couldn't, say, deny someone the ability to be a graduation speaker simply because they're transgender. There's general educational protections against discrimination for this community. And that is distinct from the injuries being complained of with respect to, in particular, bathrooms and pronouns. And so they did seek a stay with respect to the definitional provision. But again, that was denied at the Intermediate Appeals Court. And then at the Supreme Court, they sought the partial stay of the sweeping injunction with the exception of the two provisions that they did not seek a stay of.
Coming up next, so what split the court 5-4? This is Bloomberg. So it was a 5-4 decision, but all 9 members of the court agreed that the parts of the rules that include the protections for transgender students, the definition of sex discrimination, including gender identity, and the restrictions on same-sex spaces shouldn't go into effect until the legal challenges are resolved. But tell us why the majority, the 5, in a very, very short opinion, agreed with the lower courts.
So this is where things get complicated and pretty unfortunate. And that is, again, this is all happening on the shadow docket in the context of emergency relief without the benefit of full briefing and without the benefit of oral argument in a per curiam order that is, as you note, 2.5 pages. And 2.5 pages addressing legal issues that are underlying a host of cases in the lower courts over many years, and then a 1,500-page rule. And this cursory treatment just shows the hazards of the shadow docket and how, unfortunately imprecise it is, and then what happens with critical pieces of federal administrative action, and then, of course, the rights and responsibilities of individuals across the country. Because you have this 2.5-page order, which in essence doesn't really say anything, and in fact misconstrues the United States' stay application, in essence suggesting that they have not sought relief from the injunction against the definitional provision. And so they sort of just ignore that. And then I think this is really important, and it is also unclear, but this is how I'm interpreting it. And then the question is, in essence, are they likely to succeed on the merits, meaning they, the United States, on the merits of the claim that you can sever the provisions that the alleged injuries flow from the rest of the rule? And in essence, the per curiam order says no, they are not likely to succeed on that claim, in essence, that they're all interconnected, in part because this definitional provision is sort of at the center. But they don't in any way contend with several of the arguments that the United States has raised, and, somewhat curiously, and I would say disingenuously, they suggest that the United States has not explained how you could sever those things, even though in their briefing they say, so quite clearly that an injury related to trans people using the bathroom has no impact on the rest of the rule concerning whether or not you could, for example, kick a breastfeeding student out of school. And I think intuitively any person understands these to be discrete things, even when it comes to, the overall authority of the government to promulgate these rules with respect to the meaning of Title IX. So the majority's 2.5-page order, as far as I can tell, doesn't really take the United States arguments at face value. It doesn't even seem to contend with them as they were presented. And in essence just suggests that these provisions rise and fall together.
Let's talk about the 4 in the minority or dissent, which was the 3 liberals and Justice Kovacic. And they at least wrote 9 pages. What was their dissent about?
Well, that's a great question. What was their dissent about? They wrote more, in terms of the number of pages, not much more. And they don't challenge, first and foremost, they don't challenge the majority's misrepresentation of the United States position. So in essence, we end up with this very hard to follow, very cursory, order and dissent that does not seem to be responding to what is actually presented before them. And so the dissent leaves unchallenged this idea that the United States has, in essence, conceded to leave the definitional provision in place. So that's a big problem because it sort of does not get at sort of the fundamental question of their stay application, which is that, there's a huge amount of harm flowing from this, and in fact, these provisions can be severed from one another, and here's how and why. Not to mention, there is within the United States' stay application argument that the definitional provision is compelled by Bostock. In other words, the Supreme Court has already held that, at least in Title VII, which usually is interpreted to be the same with respect to whether or not something is because of or based on sex, has held that it is because of sex to discriminate against someone because they are transgender. This seemingly obviously flows from that. But there's a lot of confusion here because it is not clear when the dissent says all 9 members of the court agree that the respondents were entitled to the underlying relief, what that refers to, and if, in fact, all 9 members of the court agree on anything, especially given the misrepresentation by the per curiam order of what the United States position actually was. And so I hesitate to say what this means or says, because it seems unlikely that they meant the states were entitled to relief on the merits, that somehow, Title IX's protections can't be interpreted to include LGBTQ students. I find that to be a very unlikely interpretation of what this very curious sentence in the dissent is referring to. That said, it is unclear, and it is causing, obviously, a lot of confusion among people who are trying to decipher this short but impactful order. My interpretation of it is, in essence, that, as to the provisions, first, that everyone has either agreed or has misrepresented that are not being challenged with respect to a stay. So in other words, the provisions that the court has said nobody is seeking a stay of the injunction as to those, my read is they're saying everyone agrees that the alleged injuries allow them to receive injunctive relief as to those provisions. In other words, that was a proper scope of remedy, not necessarily that they were entitled to relief on the merits.
Justice Gorsuch wrote the Bostock opinion, as you know, and he sided with the liberals here. Is it surprising to you that the Chief Justice, who joined in the Bostock majority opinion, sided with the other conservatives here? I mean, do you read anything into that?
Well, so, again, I'm not exactly sure, and I hesitate to guess what any of them are suggesting as to the underlying merits question. That is to say, whether or not Title IX can or must be interpreted in such a way that includes prohibitions on discrimination against LGBTQ people. Because I think, and again, coming back to the extraordinary hazards of the shadow docket and these emergency orders, it's very possible that everyone is just weighing in to one degree or another on what is the appropriate, scope of the injunction vis-a-vis the claimed injuries that the states alleged in their initial filing. I recognize that that is somewhat difficult to square with some aspects of the order and the dissent, but I also don't think it's clear what everyone is referring to at various points. So, in some sense, it is possible to me that you have a per curiam order that reflects a subset of the justices saying, 2 circuits have said these things, multiple district courts have enjoined it, we are in this emergency posture going to let it stand. Do I think that's a consistent position with what they've done in other cases? No. But could that be what's happening here in a Friday night order in August with very little reasoning? Maybe. So I would say in terms of whether or not it means that the chief, sort of has a limited interpretation of Bostock's reach with respect to other statutory and constitutional protections for trans people, I'm not willing to sort of hazard a guess on that just yet. But I don't think either of these, the order or the dissent, are particularly encouraging endorsements of this Title IX rule. I think it is deeply upsetting in terms of what it means for people across the country, because we now have a regulation that is in effect in some parts of the country and not others, with some provisions, enjoined to varying degrees depending on the circuit. And obviously, as a enforceability, administrability matter, that is horrible for the federal government, but it's also horrible for the individuals who are trying to protect their rights under Title IX, and it's also horrible for the entities that are, trying to comply with their obligations under Title IX.
Next term, the Supreme Court is going to take up the issue of gender transition care in a Tennessee case. Do you think that in that case the court will actually decide the issue once and for all?
Well, so in Scrimetti, which is a case that the court is going to be hearing this term, which comes from the United States petition out of the prohibition on medical care for transgender adolescents in Tennessee, the question is whether or not these laws that categorically prohibit medical care for transgender minors violate the Constitution. And so they will be answering, sort of one set of questions with respect to the ways in which transgender people, and particularly transgender youth, have had their rights attacked by state legislatures. And the question there is really, is it sex discrimination? Is it trans status discrimination when the government draws these lines based on gender transition and categorically prohibits this medical treatment? This is a constitutional case. I think the main question is really what level of scrutiny is going to apply and whether they resolve it in such a way that answers other questions, whether they don't. I think that is still very much up in the air. I think whatever happens in Scrimeti, they're going to separately have to contend with the Title IX regulations, because at this point it seems that this is going to be percolating in the lower courts and likely to end up at the Supreme Court. Of course, all of that is dependent on what happens in the election, because these are rules that are promulgated by the Biden administration's Department of Education. If, Trump wins the presidency, those rules will be rescinded, or they will no longer enforce them, and then they will seek to promulgate new rules and probably have some sort of temporary rule rescinding the old one. So some of this all depends on what happens in the election. And then with respect to the constitutional challenges to the gender-affirming medical care bans for adolescents, the Supreme Court is going to consider those. They are going to, have to contend with what is the nature of discrimination against trans people and what is the reach of Bostock. And then also, because the states have argued that these cases are governed by Dobbs, also what is the reach of Dobbs. So there's a lot that's already up at the court imminently, and I expect there will be more. And obviously trans people and their families are just trying to live their lives.
Conservative states have passed a slew of laws aimed at transgender youth, including restricting treatments like puberty-blocking drugs, hormone therapy, or surgeries for minors experiencing gender dysphoria, laws regulating bathroom use and pronouns. Which laws affecting transgender youths are the most common in these states?
Just to give sort of a temporal framework here, in 2020, no states had any of these laws. And now we're in a situation where half the country, so about 24 states, banned both medical care for transgender adolescents related to gender transition, as well as the inclusion of trans girls in sports. Those are the main central pieces of legislation that have been passed in the most. Then the bills that ban trans students from the bathroom are, increasing in number. And there's, sort of about 10 or so states that ban or restrict the ability of trans students to use the restroom that aligns with who they are. Then there's, a number of other laws that are, increasing that we're seeing, including, sort of the Don't Say Gay style laws, so restrictions on discussions of LGBTQ people and content in schools. There's restrictions on the ability of students and school staff to use pronouns that accord with their gender identity. So those are sort of percolating and expanding, but I would say the primary legal frameworks or emphasis of states across the country over the last 3 years has been banning medical care and inclusion in sports.
An unbelievable number of laws in just about 3 years. Thanks so much for joining me today, Chase. That's Chase Strangio, Deputy Director for Transgender Justice at the ACLU. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.